Hanging in the balance. SCOTUS sits on tariffs and the National Guard cases. Welcome to Law and Society. Let's talk briefly about the two cases that are up at the Supreme Court. So I don't understand why the judiciary works in such a slow, deliberative manner, but maybe the answer is they want to be deliberative as opposed to make mistakes. But the cases that go up on appeal to SCOTUS should be ruled on in a timely fashion and not take months in order for them to pass through the highest court in the land, because the issues at hand impact everyday Americans on a fundamental level. So the two cases that I'm going to talk to you about is the first one is the tariffs case. In the tariffs case, the Supreme Court heard the full argument on the merits after the Court of International Trade and the Court of Appeals for the Federal Circuit ruled in favor of the companies that had sued Donald Trump's regime for improper use of the statute that is the International Emergency Economic Powers Act, and Donald Trump used that to tariff as opposed to regulate. IEPA, according to the plaintiffs, does not give the president the authority to tariff. And the authority to tariff and the authority to regulate are two separate powers of Congress that Congress must specifically delegate to the president for the president to be able to wield those powers. And the plaintiff's argument is that IEPA does not give presidents the right to tariff, it gives them the right to regulate. And because of the tariffs that are imposed by the Trump administration on various goods coming out of our major trading partners, China being foremost among them, it is raising the cost on everything from electronics, technology, to toys. So, because one of the plaintiffs in the case, Learning Resources, is a small toy-making company. So the court heard the oral arguments. Their question was whether IEPA authorizes and whether regulating means tariffing. And Donald Trump's regime's position is that saying regulating importation is tantamount to saying tariffs. The court didn't seem to accept that argument. But again, the court is still hanging on to that case over 2 weeks after it has heard the case. Maybe it has to go through some procedure. Maybe it has to go through the clerks and all of that. But if you give the American public at least an idea of when you're going to rule on this, this is having an impact on American lives on a daily basis. It's raising the cost of consumer products on one side, and on the other side, it is raising the cost of businesses doing business and getting their various parts from our trading partners. And because of these raised prices, the final product coming out of even American companies are going to be higher than they were before. So, it makes a difference in the lives of American people every day if everyday items start going up in prices, like coffee and beef and regular grocery items, to the point where most families cannot afford to get basic food necessities in order to make ends meet. And the Supreme Court should be aware. There should be a real world advocate for the Supreme Court. Like when I was in law school, I used to be a domestic violence liaison to the court who would specifically advocate for the domestic violence victims on behalf of the domestic violence in court. And so I believe that there needs to be a sort of real world advocate for the Supreme Court to keep reminding them and nudging them, saying that, hey, listen, this is having an impact on American lives on a daily basis. So can you please hasten your ruling? The second case that has gone up to the Supreme Court is an interlocutory appeal, which is at the temporary restraining order stage. It is a National Guard case of whether the National Guard can be deployed in the state of Illinois or not. And the Supreme Court asks the question of whether regular forces, as mentioned in the statute 12406(3), means active military, or if it means Donald Trump's DHS federal personnel. And the argument is that because the precondition of deploying armed forces was not met in 12406(3), the president could not even invoke raising the National Guard because he hadn't even allowed the regular forces, which is the armed forces, to go in. Now, Donald Trump's argument here is that his forces, his DHS federal agents and his army, those were the regular forces that he was talking about. And even if he was using those forces as regular forces, there's no showing that Donald Trump was unable to carry out federal functions because of what was happening in Illinois with protesters. So there's no showing of the inability to enforce the law of the United States. And on the flip side of that, you have the National Guard, the National Guard not having the authority to even be deployed on American streets. So that is an interlocutory appeal that doesn't go to the merits. That the Supreme Court is going to ask the question of whether the plaintiffs are going to win in a fact-finding way in the lower court. If they are likely to succeed on the merits, then the Supreme Court is going to say that the National Guard can't be deployed. And if the Supreme Court holds that regular forces means the military, then they're going to rule that the precondition for deploying the National Guard under 12406, the statute, has not been met. Even if the Supreme Court were to hold that Donald Trump's ICE agents and DHS could be perceived as regular forces, there's no showing that they met the precondition that they were unable to carry out their duties, or in some way they were stopped from carrying out their duties so as to deploy the National Guard. Whatever the case may be, the Supreme Court hasn't ruled on it yet, hasn't asked for oral arguments on the matter of what the meaning of regular forces is, and it's just sitting in the Supreme Court. Now, that is costing the American people money because the National Guard has been deployed from Texas and the Illinois National Guard, and housing the National Guard takes money, taxpayer dollars, and they are just hanging out in the barracks because they have been enjoined from being deployed. And that in and of itself should give the Supreme Court reason to hasten their order of how to proceed with the National Guard. Yet it has been nearly a month now since this issue has come up, and at least a week since the Supreme Court has received the briefs from both the parties in order to rule on the matter. And we haven't heard anything yet. So the court has heard oral arguments in the tariffs case, and it has had all the briefings needed for the Illinois Guard deployment case, and yet the court remains silent. Both these issues are of immediate concern. How the court can keep waiting, I will never understand. They should be holding oral arguments about the guard case, and they should be ruling on the tariffs case as soon as possible. But we haven't heard anything yet. This lackadaisical attitude must be subject to reform. If more funding is needed for more clerks for the justices, then that must be considered. If more justices is the answer, so each justice is not overburdened by cases from several circuits, that must also be considered. Whatever needs to be considered so our courts start moving at a pace that is in step with how fast society is moving and the impact of each case and the impact it has on the society at large when it comes to tariffs and then when it comes to deploying the National Guard, which is meant for times of rebellion and insurrection. And there's no showing that any of that has happened. With that said, that's your catch up for what's happening in the Supreme Court, and I'll get back to you more about it when the Supreme Court rules on the matter. Remember to like, share, and subscribe, and I'll talk to you soon.